So, okay, so now here's a really good question for you. I'm a new home inspector. I just started out my business. I followed your rules. I got my federal ID number. I got my business name legally done. Whatever. I did everything. So when it comes to an inspection contract, should I just use what my friend, the other inspector's contract is? Just use that and not worry about it?
I wouldn't. Now, understand that if you belong to CREIA, CREIA has a pretty good contract, in all honesty, and we'll go through it later. But you'll see things, for an example, which were unenforceable, which I changed to make them enforceable. For an example, the 1 year statute of limitations versus 4. Mm-hmm. Most people think that in a written contract, it's 4 years. And in California, it is.
Yeah, it is. Yeah.
Well, it may be.
You changed the rules?
Yeah, sure. and this is how we did it, is that no, let me stop for a second. That isn't really true about it is. There is case law, for instance, that says in insurance death policies, so you have a life insurance policy and somebody dies, depending upon the terms and conditions of that very long agreement, like we talked about the escrow, there may be a clause in there that says we must know within 6 months, not a year or not 4 years. And there's case law at the Court of Appeals that says if there is a specific time limitation based upon consideration that is found to be valid, there can be a reduction in the time. Now let's take CREIA, for instance, because it's really much better policy.
Yep.
California has Business and Professions Code 7195 through 7199. Everyone thinks that 7199 says there's a 4 year statute of limitations because no action can be brought against a home inspector after 4 years from the date of the inspection. That is not true. That is not a 4 year statute of limitations. That is a limitation on the filing. But you can be brought in on a cross complaint 3 years, 9 months, 10 months, 11 months later.
What is a cross complaint?
A cross complaint in an action is there's a plaintiff's complaint. They sue certain defendants. Defendants can file cross complaints against various parties. I make it a policy that if, that's why it says in my contract, that there is a duty of the plaintiff to read all the terms and conditions of the contract, of all the reports, and if they don't do so, an allegation can be made of a cross complaint against the plaintiff because the plaintiff did not fulfill their duty. I get a lot of kickback. There are a lot of people that really don't like me because of that. And you want to know something? I lose sleep every night over that. I really, really do. And I don't at all. The bottom line of it is if they're an idiot and they don't read the stuff in front of you, and it goes badly, well, this is something being recorded, so I can't say what I really want to say, but I can say that the word is a 13-letter anatomical improbability. That's what I can tell you. Bottom line of it is that a plaintiff owes a duty, a buyer owes a duty, a seller owes a duty. All of us owe duties. If you choose not to do your duty, you know what happens. You're named as a party. So that answers that question. So think of it this way. You can be brought into any case at any time. It says if, in fact, more than 4 years have passed since the date of the inspection, the plaintiff can't name you. I just got a case in the door in which it was 7 years after the inspection, a commercial inspector was brought into a lawsuit. And we are just getting the information necessary to file the motion for summary judgment. And then after we win, which we will, I've already told the client they're going to win, is that we're going to sue them for all the damages. Now, as you know, and I've told you this beforehand, we have collected, I say collected, I don't mean got judgments, I mean money in hand and divided, in excess of $1.3 million for home inspectors. And I'm getting more all the time.
Let me ask you this real quick before you continue. What is a summary judgment?
Summary judgment is a motion before the court that says, I don't care what you believe or you don't believe. In this case, it was the statute of limitations. But the statute of limitations says, worst case scenario, 4 years. Worst case scenario, everything all from a plaintiff, 4 years. Now, if it were a construction defect case, as you well know, there's a extension that can be done when it's called the delayed discovery rule. That does not apply to home inspectors. And there's a landmark decision called Moreno versus Sanchez, which is a Orange County case, came from a Los Angeles decision. So I'm sorry, that's true. That's not true. It was a Los Angeles case in which it was transferred to Orange County because the commissioner who brought the action was in Los Angeles County. So it was transferred. But the decision by the judge, it's called a centennial case, says that no, they must bring an action within 4 years, which is what Business and Professions Code 7199 says.
Got it.
So the summary judgment means there's no triable issue of fact. Therefore, as a matter of law, the court must grant it. The best ones are in statute of limitations because that's a definitive time.
Right. So summary judgment, you're basically saying you have nothing.
You have no case against this person under these facts.
And now you're asking for a sum of money in return for or not.
Well, what occurs is when the summary judgment's granted and it runs through the appellate period, you then file your cost bill. Now, if you have the right contract, in other words, if you have my contract, what occurs is there's an attorney fees clause.
Yep, and that's... We're going to talk about that.
Oh, yeah. I bet you're going to get into that. Yeah. And it's amazing how much they like the money coming back. One of the former presidents of the LA Ventura chapter, I got a judgment for in 2002 for $52,000, I think it was. But because of the rule of law on collections, the house that you try to sell for the purposes of doing it, the law changed, saying there was X amount of money that was theirs, no matter what. We had to wait until 2020 to bring that lawsuit. We waited 18 years, got the judgment extended twice, and then foreclosed on the house. These people claimed they had no money. The judge held it in bay, went up to the bankruptcy court. I went up to the Court of Appeals, and it came back down. I'm sorry, it went to bankruptcy court. We got it out of bankruptcy court, and it's amazing how this individual, who's a structural engineer, living in the house with 6 kids for all those 18 years, that was inherently dangerous. It's amazing he didn't have any money, but the next day he had $190,000 to give me. I mean, it was a miracle. I mean, everybody knows it was just a miracle.
Dude, that's hilarious, man.
So the former president of the LA Ventura chapter got his money plus interest. It went from $52,000 to $220,000 on 10% interest per year. And when you then redo the judgment, the interest on the judgment becomes the new judgment, and you get 10% interest on the interest.
Wow, that's nice. That's a good investment, actually.
Actually, it was. My wife thought it was very beneficial when I brought the money home. She liked it. Okay.
So let's see. I had a couple of things here. Okay, so another question regarding the inspection contract. Will any attorney suffice for a home inspection contract? Like if so-and-so, let's say I'm just this new guy, doesn't know who to turn to, who to talk to, can't get good advice from anybody around him. He just calls so-and-so family law and says, hey, can you do a home inspection contract? And they say, sure, we can do that for you. Is that something you'd recommend? I mean, what do you think?
Let's try it differently. If you developed a new software, and this is going to go and you're going to get patents, copyrights, or whatever you get, and various other things. Would you go to a family lawyer?
No.
If you had a medical malpractice case where a doctor unfortunately ended the life of your child, would you go to a family lawyer? The answer is pick the specialty. There's a reason why a person's in a specialty. It's because they have more background, education, experience. They know the cases that match up, and you go to a specialist. More mistakes are made by lawyers who have committed malpractice and have been found to commit malpractice by stepping out of your comfort zone.
Right. Stay in your lane.
Right. The same thing applies to a home inspector. If you do family homes or condos or so forth, you don't do 60-foot skyscrapers.
Right.
The answer is do what you do best, and do it better than anybody else.
And find the right people to set you up. So just what I hear a lot and I see a lot over the years is a lot of home inspectors. Oh, hey, do you have a contract I can use? Yeah, sure, I'll send it over. And I'm like, you're not going to have your own lawyer look at that? Because taking a step back for a second, we talked about CREIA contract. Now, just to be clear, if I use a CREIA contract and there's all of a sudden there's a claim against me, some kind of a demand, will CREIA be coming to court with me?
Of course not.
My point, exactly. So, once again, I'm sure, like you said, CREIA has a very good contract, but you still need to have this looked at by your own attorney
who specializes in that area of the law.
Right. So that's something that is unsaid and has been unsaid for a long time. No matter what meeting I went to or what conference I went to, no one's ever said, oh, by the way, you're on your own with this. You're going to have to get your own lawyer if you're not insured. But that's a different subject we'll get into shortly. But let's jump now into...
since you're right there,
okay,
let's think about this. For a long time, CREIA was told, do not have an attorney fees clause. Well, ever since I became very, very successful at bringing the money back in, it's amazing how the thought process is, I want a piece of the pie. The next thing that you'll see, and we'll go through it, is they talked about various aspects that you inspect for, but nobody mentioned systems. And if you relate everything to a system and you have the right paragraph before and you call out a system, it is a get-out-of-jail-free card for any other part of that system that you may have missed because you called out a person in the system.
Right.
That also changed. That's just another one of the ideas that, and by the way, it wasn't just me, that there's a number of people that thought this out, and we would meet every so often and go through this. Alex Kuczynski was one, Farmer. There were quite a few people that jumped into the bandwagon to upgrade it. Ashley didn't do that. Ashley was late coming into it, and Ernachi was late coming into it. As a matter of fact, it used to be that CREIA borrowed Ashley's. And because they were once together, Ashley's now coming to CREIA and say, can we see your contract? So go ahead.
We're evolving, right? Everything's evolving. Okay, so then I wanted to, let's go right into the attorney's fees clause. So I just recently, my previous podcast, I had my insurance company representative as a guest. And we talked about stuff, and we talked about a lot of stuff. Mostly, it's all about risk management once again, and that seems to be the biggest open door for a lot of home inspectors. They're not quite aware of a lot of these details. So when she got to the topic of attorney's fees clause, she called me out on that, and I said, well, I don't mind you calling me out on it. It's in my contract because I had a very experienced lawyer do it. So what don't you like about it? The insurance company I use, Inspector Pro, is not a fan of it. Well, so hang on.
Good, sure.
So she kind of, was just like, well, we had it work in reverse before. So basically, somebody had that clause, a home inspection company that they represented, had that clause in their contract. Turns out they were found
negligent.
Not negligent.
Okay.
And basically they were told, okay, you're not at fault here. However, because it said that clause was in the contract, the plaintiff, they were ordered to pay so much money for all the attorney's fees that because of the rest of the people involved in the case. So I'm like, how did that happen?
Okay. This is a bigger problem, and
Right.
maybe now's the time to talk about it. California is different than New Jersey,
Right.
which is different.
And that's what I brought up.
Right.
Yeah.
Now, Louisiana, the law is based upon French, or really it's called Napoleonic law. And Texas is different, and all of them are different. That is the problem that we have at CREIA. We have a different world. We don't want to be dictated to by another entity that has different rules, different regulations, and the way to get around it, we have figured it out in California.
Right.
Keep the attorney fees clause. What you do is you then go to what we call a CCP 998, Code of Civil Procedure 998. And that is called a statutory offer of compromise. So where we have, let us assume that we have a home inspector who just, whatever reason, had a bad day. And it's a 3-bedroom house and they only inspected 2. And the third one was a disaster.
Mm.
What they do is they analyze the actual cost to rebuild that. And then you say to that person, we are willing to rebuild it, and let's assume that it costs $30,000 to redo that bathroom. They make a statutory offer of compromise at $30,000 plus 10%, just in case the bid's a little over. And they do a statutory offer for, hypothetically, $33,000. If the jury comes in, and it has to do with everyone, and let's say your proportionate share in California is $20,000. You're responsible for 20, but the other parties should have noticed the same thing, and they were found to be less responsible, and they're held for $10,000. The fact that you offered $20,000 and they didn't take it means that you are the prevailing party and you get your attorney fees. And there was a landmark decision having to do with construction defect where there was a problem with plumbing. It wasn't soldered correctly. And in fact, it went through 50, 60, 70, maybe it was 100 homes in a large development. A construction defect case came about. The plumbing company, day one, came into the case and said, you're right. This is what it would cost to fix it. This is your downside, and made them a statutory offer for, it was in the millions. They wanted a lot more. They won the case.
Who's they?
That is the plaintiffs in the action.
Okay.
Won more than the amount, and let's say the amount was $2 million. They won the case for $20 million, but as it relates to the plumbing problem, it was less than $2 million. That the attorney fees were greater than the $2 million at the end of the case. The plaintiffs in the case ended up paying on the statutory offer. They had to pay the attorney fees and costs.
Oh, wow.
Yes. So what it means is you have to be reasonable. So let's just take our case that we just had. Well, all they had to do at InspectPro is to do a statutory offer of compromise for an amount worth more than the claim is being made. And had that occurred, yes, there may have been a $20,000 instead of $30,000, but the attorney fees done by the lawyer on that case itself, and all the other attorney fees from all the discovery done by everybody else is all added in. So I'll give you an example. We had the Miss Google case, the one I told you about beforehand that had like 8 or 10 lawyers. And the bottom line of it is that it...
Did you say Miss Google?
Yeah, Miss Google. She was a high executive for Google, a big time player.
Okay.
And she came from a very wealthy family, and her husband was one of the 5 big milk producers in California. Look, they had more money. When old money was old, they had old money. Okay, and it was a terrible situation, terrible thing with the house. It was a disaster. I could spend 2 hours just talking about that, and I wouldn't even cover it. We figured that at the end of the case, we had to process in excess of 1 million pages of documents.
Wow.
Yes. Okay. All I can tell you is this, is that that was just an example of the way these things take place. And that's why you do things the way they're set out by code. So the answer is all they have to do, and if that issue comes up, all they have to do is a statutory offer of compromise. And it's done every single day.
Right.
In PI, it's done all the time. It's a standard thing. So,
but I think what you're getting at is each state, it may work differently.
no, I'm saying the law is different. I'm saying in California, all they have to do is a statutory offer of compromise, and they resolve the whole thing about the attorney fees.
Got it.
It's a non-issue.
Okay. So I'm pretty sure the people she was mentioning were from a different state. So like I said, different laws over there.
No, it's in California. I hear adjusters say the same thing over and over and over, and I stop and I write a report on it saying, no, this is what you do to correct it. The problem is the adjusting services, because a home inspection industry is so small, there's so little training. They don't know what you do. Right. That's the problem we have. That's the biggest problem in CREIA right now.
Got it.
And we'll go into that later. Go ahead.
Right. Okay. All right.
Attorney fees is a non-issue.
Non-issue. I like to hear that. All right. That's good.